Welcome to The Explainer. Today we're diving into a really provocative law review article from Professor Dru Stevenson. He argues that a recent unanimous Supreme Court decision was, believe it or not, unanimously wrong. The case, of course, is NRA versus Vullo, and the article is titled Siding with Goliath. So that's the big question, isn't it? How can a 9-0 decision possibly be wrong? I mean, we usually think of unanimous opinions as the easy cases, just straightforward applications of precedent. But Stevenson's whole point is that in NRA v. Vullo, that unanimity is actually hiding a really fundamental mistake, a misapplication of the First Amendment's coercion doctrine, and, just as importantly, a misunderstanding of how modern financial regulation actually works. So, here's our roadmap. We're going to walk through Stevenson's argument in 6 parts. We'll look at his claims about coercion versus regulation, the chilling effects on government officials, the proper role of reputational risk, and then we'll get into his really novel idea for a new analytical framework. Let's start with the central paradox of the case. Okay, so right at the heart of Stevenson's critique is how the court framed this entire dispute. He argues that the justices basically constructed a narrative that turned the power dynamics completely upside down. They painted the NRA, a massive political and financial organization, as this vulnerable little speaker, while portraying Maria Vullo, a single state regulator, as some kind of all-powerful censor. So the case itself comes from a lawsuit the NRA filed against Maria Vullo, who was the superintendent of New York's Department of Financial Services. The NRA's claim was that she used her regulatory power to strong-arm financial institutions into cutting ties with them, which they said was unconstitutional retaliation. Now, for all you procedure folks out there, here's the absolutely crucial detail. This case got to the Supreme Court on a motion to dismiss. What that means is the justices had to take all of the NRA's factual allegations as true. Stevenson argues this is key because it meant the court was analyzing this kind of hypothetical, worst-case scenario of coercion, not the much more complicated reality you see in the actual regulatory record. And this quote just lays Stevenson's whole thesis out on the table. He's saying, the court took the government coercion framework from cases like Bantam Books v. Sullivan and completely misapplied it. He thinks they expanded the doctrine without really grappling with the unique context of a highly regulated industry. And in his view, by treating what he calls legitimate regulatory guidance as unconstitutional censorship, the court ended up siding with Goliath. Okay, so to properly analyze whether this was coercion, Stevenson argues that you have to look at the backstory. The story the NRA tells is pretty simple. It's all about viewpoint discrimination. But when you look at the timeline of events, a very different picture emerges, one that's grounded in legitimate regulatory enforcement, which, as you know, really complicates the First Amendment analysis. This timeline is absolutely central to Stevenson's argument. The key fact is that the DFS investigation into the NRA's Kerry Guard insurance started way back in 2017. That's well before the tragic Parkland shooting and before Vullo issued those guidance letters. And the investigation wasn't about speech. It was focused on specific alleged violations of New York insurance law. Things like providing coverage for intentional criminal acts and selling insurance without a license. Stevenson argues this pre-existing enforcement action provides a totally legitimate, viewpoint-neutral reason for Vullo's later communications. It separates what she did from a punitive campaign that's motivated only by the NRA's political speech. So this context really forces us to make a critical legal distinction. Was Vullo engaged in viewpoint discrimination, just using her office to go after a speaker she didn't like? Or was she doing her job, conducting legitimate regulatory oversight, and warning a regulated industry about the very real legal and reputational risks of doing business with an entity that was already under investigation for unlawful conduct? Stevenson, of course, argues for the second interpretation. And this is where Stevenson really zooms in on the precise language Vullo used. Words like encourage, evaluating, and managing, he argues these are basically terms of art in the world of prudential supervision. They aren't threats. Unlike the precedent in Bantam Books, there was no informal censorship, there was no blacklist, and there was no direct threat of punishment if they didn't comply. This was non-binding communication, a totally standard tool for financial regulators. This brings us to what I think is one of Stevenson's most important contributions to this whole debate. He says the court spent all its time analyzing the chilling effect on the NRA's speech, but completely ignored a different and maybe more dangerous chilling effect, the one this ruling is going to have on public officials. Yeah, we all know the traditional First Amendment concern is about chilling private speech, but Stevenson just flips the whole question on its head. He asks, what happens when a huge, powerful private group can credibly threaten a government regulator with years of incredibly expensive, career-ending litigation? He argues that the Vullo decision basically writes the playbook for how to do that, creating a brand new chilling effect on the very act of government. So the court's analysis, as Stevenson lays it out, was completely one-sided. It was laser-focused on the Bantam Books scenario over on the left, the government chilling a private speaker, but it completely failed to grapple with the risk on the right, which is the whole reason we have doctrines like qualified immunity in the first place, to prevent a world where the fear of retaliatory lawsuits from powerful, litigious groups basically paralyzes public servant. And this isn't some newfangled idea. This exact problem was articulated famously by Judge Learned Hand in Gregoire v. Biddle. The whole doctrine of official immunity exists for this precise reason, to prevent the dampening of the ardor of public officials. Stevenson argues that the Vullo decision really undermines this entire principle by letting a plausible First Amendment claim move forward based on what he sees as routine, non-coercive regulatory talk, which exposes officials to that exact burden of litigation that Judge Hand warned us about. Next up, Stevenson really tackles this concept of reputational risk. In the Supreme Court's opinion, Vullo's mention of it was treated like a veiled threat, a kind of wink and nod reference to the NRA's politics. But Stevenson's article just systematically takes that interpretation apart, reframing reputational risk not as some kind of threat, but as a formal term of art that is central to modern financial supervision. Now, the court's opinion really just glossed over this. But as the U.S. Solicitor General's amicus brief made very clear, reputational risk is a formal, recognized category of risk that both federal and state regulators are actually obligated to monitor. It's a key part of the safety and soundness exams that have become standard practice, especially since the 2008 financial crisis. For a regulator to just ignore it would be a complete abdication of their duty. So Stevenson's argument here is that a regulator's job goes way beyond just looking at the balance sheets. I mean, financial firms are built on public trust. So when a business partner like the NRA becomes intensely controversial, especially when that's piled on top of existing legal violations, it creates a tangible risk of boycotts, of divestment, of real instability. Pointing that out isn't viewpoint discrimination. It's just prudent supervision. It's a practice that other states explicitly endorse as well. When you put Vullo's actions in their proper doctrinal context like this, the contrast is, well, it's stark. The coercion in Bantam Books, that involved officials sending actual lists of objectionable books to distributors and reminding them of their power to prosecute. In the Backpage.com case, you had a sheriff demanding that credit card companies immediately terminate services. And then you have Vullo, who issued general, non-binding guidance letters to an entire industry. Stevenson argues that calling Vullo's actions coercive in the same league as these others is just a category error that dramatically lowers the bar for what counts as unconstitutional coercion. Okay, now we get to what is probably the most novel part of Stevenson's entire argument. He imports an analytical framework from Fourth Amendment case law to critique the court's First Amendment reasoning. He says the court totally failed to apply the logic of marginal deterrence, which is a test it uses all the time in other constitutional areas. So the Supreme Court actually developed this marginal deterrence framework to analyze the exclusionary rule. The logic, which you see in cases like Herring v. U.S., is that the social cost of throwing out evidence, possibly letting a guilty person walk, is only justified if it actually deters future police misconduct in a meaningful way. So the court has been really reluctant to apply the rule when it's just mere negligence, because it concludes the deterrent benefit is marginal while the cost to society is high. So Stevenson's big point here is that the court's failure to do this exact same cost-benefit analysis in Vullo is a glaring doctrinal inconsistency. By letting the NRA's claim go forward, the court created this new layer of protection for speakers against regulators, but it never stopped to ask the critical question: does the tiny benefit of this new protection really outweigh its massive social costs? And when you apply this framework, just like this chart does, the imbalance is pretty staggering. What's the marginal benefit of the Vullo ruling? It's pretty close to zero. The NRA's ability to speak was never seriously in jeopardy. But the cost? The cost is systemic. It's not just about this one case. It's about creating a legal minefield for every single regulator who has to communicate with a powerful, politically connected entity. Stevenson's conclusion is that when you analyze it properly, the benefit-cost ratio is just deeply, deeply unfavorable to the court's ruling. Finally, the article moves from critique to consequence. It warns about the dangerous playbook the Vullo decision could create and its potential to actually weaponize the First Amendment against the administrative state itself. The consequences, as Stevenson spells them out, are systemic. The ruling effectively gives a litigation playbook to any powerful actor that wants to challenge a regulatory action they don't like. It risks transforming the First Amendment from a shield that protects dissenting speech into a sword used for deregulation. And that creates these perverse incentives for selective enforcement and chills the very government speech that's necessary for markets and laws to even function.
In the end, Stevenson's article really leaves us with this pretty unsettling question. Is the First Amendment, which we've long thought of as a shield for the dissident and the powerless, being repurposed into a tool for powerful economic actors to fight back against regulation? By siding with Goliath, he argues, the court might have unintentionally opened the door to a new kind of First Amendment Lochnerism, using speech rights to achieve deregulatory goals. And that's a result that the framers almost certainly never intended.